The Constitutional Confrontation, a fictional story. What you're about to hear is a work of fiction, but it explores very real questions about constitutional consistency and judicial accountability. The silence in the congressional hearing room was deafening, not the kind of quiet that comes from boredom, but the electric stillness that follows when everyone realizes they're witnessing history unfold. Supreme Court Justice Brett Kavanaugh sat frozen, his confident demeanor replaced by something nobody had seen before, genuine uncertainty. Across from him, Representative Denzel Washington remained perfectly calm, his voice steady as steel as he delivered what would become the most devastating constitutional critique in modern congressional history. But to understand how we got to this moment, why it hit so hard and why it changed everything, you need to know who these two men really are. The setup: Justice Brett Kavanaugh, 59, had served on the Supreme Court since his explosive 2018 confirmation. Yale-educated, shaped by the D.C. Circuit, he carried himself as a strict constitutionalist in the tradition of Scalia. He spoke often about constitutional order and remaining above partisan politics, even as his decisions repeatedly fractured along ideological lines. Representative Denzel Washington was different. In his second term representing California's 43rd District, he didn't come to Congress for sound bites or political theater. He came from the courtroom, a veteran civil rights attorney who had stood alone against corrupt institutions, defended activists, and argued constitutional cases before hostile courts. What the press didn't know, what nobody in that chamber knew until he spoke, was that Washington had spent 6 months quietly leading a review of the Supreme Court's First Amendment decisions. Working with legal scholars from Yale, Stanford, and Howard, he had compiled a devastating pattern of ideological selectivity that no one had dared confront directly. Until now, the moment everything changed. The House Judiciary Committee hearing was supposed to be routine, a standard oversight session on the court's recent First Amendment decisions. Justice Kavanaugh had just finished answering softball questions, his tone seasoned and composed. Then the chairman called. "The gentleman from California, Mr. Washington, is recognized for 5 minutes." Washington adjusted his charcoal suit jacket, the Constitution pin on his lapel catching the light. He opened a sleek black binder with surgical precision. "Thank you, Mr. Chairman. Justice Kavanaugh, I appreciate you being here today." The justice nodded, expecting routine pleasantries. "I want to focus on something you've emphasized in your opinions. Constitutional consistency. In Americans for Prosperity versus Bonta, you wrote, "Consistency in constitutional interpretation is essential to the rule of law." Is that still your position? Yes, Congressman. Consistent application of constitutional principles is fundamental to the court's legitimacy. "I couldn't agree more," Washington replied, but there was something colder beneath his courtesy. "So let's walk through that together." The surgical dissection. What followed wasn't political attack. It was a clinic in constitutional law. Washington opened his binder to the first tab. In Bonta, you applied strict scrutiny to disclosure requirements for charitable donors. Yet in McKesson versus Doe, a protest case, you allowed a protest organizer to be held liable under a far lower standard. Help me understand what constitutional principle justifies treating the same First Amendment right so differently. Kavanaugh blinked. Those are very different contexts. Both involve freedom of association. Washington cut in, his voice cool and direct. In Bonta, the burden was information disclosure. In McKesson, it was financial ruin for leading a protest. Why does the former get strict scrutiny while the latter gets abandoned? The room went still. No shifting chairs, no murmuring, just eyes trained on a Supreme Court justice visibly calculating his response. Washington didn't wait. He turned the page with deliberate precision. "Let's talk about Kennedy versus Bremerton. You sided with a majority. A public school coach had the right to pray visibly on the 50-yard line. The court said even the possibility of coercing students wasn't enough to stop that expression." He raised an eyebrow. Yet in City of Austin versus Reagan National Advertising, decided months earlier, you allowed restrictions on signs based on speculative concerns about aesthetics. Both cases weighed expressive rights against hypothetical harms. But in one, you protected speech like it was sacred. In the other, you let the city silence it. Kavanaugh shifted uncomfortably. Congressman, these are complex constitutional issues that depend heavily on context. I'm not reducing them, Washington replied, his voice low and clear. I'm holding them up to the light. Because if consistency is what the Constitution demands, then selective application is what undermines it. The mistake. That's when Justice Kavanaugh made his fatal error. With all due respect, Congressman, he said, his tone unmistakably condescending. These are complex constitutional matters that require significant legal expertise. The room held its breath. Everyone knew he had just underestimated the wrong man. Washington didn't flinch. He locked eyes with Kavanaugh, still as stone. Justice Kavanaugh, before I ever walked into this building, I spent 15 years in courtrooms defending constitutional rights. I've argued First Amendment cases that made it to the Fifth Circuit. I've stood next to clients whose lives were shattered by government overreach. So when I speak about constitutional principles, I know exactly what they look like in practice. The silence was deafening. The revelation. Washington walked the screen and displayed two Supreme Court opinions side by side. In these two opinions, both in the past 2 terms, your court applies strict scrutiny to protect religious speech and rational basis to nearly identical secular speech. The Constitution doesn't say one gets more protection than the other. You said it yourself. The First Amendment protects freedom of speech, not a hierarchy of beliefs. He opened another folder, revealing historical documents and early Supreme Court opinions. The original public meaning didn't pick favorites. It didn't say religion gets more rights than labor, or that corporations get more speech than protesters. And yet here we are. Washington displayed a devastating chart. Case names, holdings, standards of review. The pattern was undeniable. I've reviewed 7 First Amendment cases from the past 3 terms. In every one, the level of scrutiny applied aligns not with the principle, but with the politics. When conservative religious interests are involved, strict scrutiny. When it's workers' rights, progressive speech, protest protections, suddenly rational basis becomes efficient. He stepped forward, his voice quieter but sharper. That's not jurisprudence. That's outcome shopping. The final blow. Washington opened his final binder with deliberate control. Justice Kavanaugh, let's speak plainly. I'd like to bring your own words into the light. He read from a 2012 Harvard Law Review article. The cardinal sin of First Amendment jurisprudence is treating similar speech differently based on who says it or whether the message is popular. Kavanaugh shifted warily. I'm familiar with my article. I'm glad you are, because I've gone through all 23 First Amendment cases decided since you joined this court. When the speaker was a religious entity, conservative group, or corporate interest, you applied strict scrutiny every time. When the speaker was a protester, labor union, or a civil rights organization, you applied lower scrutiny 91% of the time. The weight of that statistic settled over the room like a verdict. Different facts, yes, Washington continued, but same principles. Or at least they're supposed to be. That's your own rule, not mine. He leaned forward slightly. The First Amendment doesn't care if a message is convenient or disruptive. It doesn't carve out safe spaces for corporate faith while silencing civic resistance. If we're going to uphold the Constitution, we have to uphold it for everyone, or we're just playing favorites under the robe. The moment of truth. Washington's voice dropped to its final, devastating register. Justice Kavanaugh, I respect the institution. I respect the robe. What I'm questioning is what that robe protects. And who? Because when this court applies strict scrutiny to speech it favors and turns a blind eye to speech it doesn't, you don't just shake faith in rulings. You shake faith in justice itself. Kavanaugh sat frozen, his judicial armor dulled by the weight of his own record being read back to him. The greatest threat to First Amendment freedoms isn't government restriction. It's the growing belief that constitutional protection depends on who you are and what you're saying. Not the law, not precedent, but the profile. Silence. No grandstanding, no applause line, just truth hitting bone. The aftermath. Within hours, clips of the exchange had gone viral. Not celebrity viral, substance viral. Over 30 million views in 24 hours. Harvard Law professor Lawrence Tribe tweeted, In 50 years of studying constitutional law, I've rarely seen a Supreme Court justice so thoroughly challenged on jurisprudential integrity. Even conservative voices couldn't ignore it. Former federal judge Michael Ludwig posted, "While I support many of the court's recent decisions, Congressman Washington raises legitimate questions about principle consistency that demand real engagement." The story transformed from a single moment to a movement. Law schools requested permission to use the exchange in constitutional courses. Georgetown announced a symposium on scrutiny and consistency in First Amendment jurisprudence. Yale Law Journal commissioned a special issue examining the disparities Washington had exposed. The legacy? 1 year later, the impact was undeniable. Justice Kavanaugh's subsequent opinions showed a marked change. Scrutiny standards became less ideologically fragmented and more textually faithful. Legal scholars called it the post-hearing pivot. The Georgetown Law Journal published a comprehensive analysis confirming every inconsistency Washington had identified. It became required reading at Columbia, Stanford, Howard, and beyond. Perhaps most tellingly, a new constitutional law casebook opened its chapter on scrutiny standards with a full transcript of Washington's questioning. The chapter closed with a single sentence: "The strength of our Constitution is not that it silences critique, but that it survives it." The question that remains. In the end, Denzel Washington didn't just ask a question. He became the question. Do we still believe the Constitution protects everyone equally, or only those we already agree with? His voice that day wasn't loud or flashy, just steady, clear, unflinching. He showed that the most powerful weapon against institutional arrogance isn't anger or politics, but preparation armed with principle. And in a republic that must never forget how to question, in order to protect, that lesson echoes still, because true justice doesn't wait for applause. It waits for accountability.